Thank you, Mr. President. I rise today to speak in opposition to SB 377. We've heard a lot from our Republican colleagues about the things that this bill allows. They've stated plainly yet defensively that they aren't against teaching an accurate history. They want Georgia students to learn about the hard truths of our past. But the darkest parts of our history are not as far away as some of you might think. I want to point to some specific language in the bill that makes it clear that this bill seeks to prevent the teaching of truth. Section 1 lists the concepts that teachers in Georgia would be prohibited from teaching. Line 24 states, the United States of America and the state of Georgia are fundamentally or systemically racist. So let's unpack that a bit, because I think that this is actually the heart of the problem that many of us have with this bill. Systemic racism is defined as a persistent, racially based inequality that exists within a system in areas such as criminal justice, employment, housing, healthcare, education, government, and political representation. So when we say that the state of Georgia today, that black people who make up 32% of our population, but 60% of our prison population, well, we can attribute that to systemic racism. Not in the past, but now. When we observe that statistically in the United States, black people are more likely to be stopped by the police, detained pre-trial, charged with more serious crimes, and sentenced more harshly than white people, we can contribute that to systemic racism, not in the past, but now. When black women in Georgia are 3 times more likely to die in childbirth than white women, that is systemic racism, and it's happening now in our state. So if we can at least agree that all of these basic facts about inequity are true, what is a teacher to do if she's confronted with these facts in a classroom? How is she supposed to explain to students the reasons behind the inequality in our country and in our state? Not the historical inequalities, but the ones that are happening now, right now. If this isn't systemic racism, then what is it? Surely no one here would dare to suggest that there is something inherent in black people that holds us back, that keeps us in jail, that causes us to die in childbirth. Obviously, that's not the case. But this is exactly the reason why it's so important that we do teach about systemic racism. And the systemic racism, not that's just in our past, but that's in our present. Because without explanation, without explaining that systemic racism is real, students of today would be left to draw crushing and demoralizing conclusions about inequality, left to conclude that inequality is somehow inevitable and inherent in a particular race of people. My friends, we're going to take a vote today on this bill. And we're going to watch this overwhelmingly white, overwhelmingly male majority decide for our students what is and isn't okay to say about race in the classroom. And it's going to be written into our codes. It's going to be codified that despite all of the protests that you've heard from people of color and women in this room, people who represent millions of Georgians, we are going to codify this. And it's going to be used to accuse teachers and to punish schools simply because they dare to tell the truth. The truth that there are today some fundamental inequalities in our system. The truth that there are fundamental inequities in our systems. This bill This bill, in the process by which it was written, introduced, and ultimately may be passed, it will become in and of itself a prime example of systemic racism. A systemic racism that is being enacted before our very eyes, not in the past, but now. I yield the well.
Chair recognizes the Majority Leader to speak to the measure.
Thank you, Mr. President. First of all, I am proud of the way the Senate has conducted itself today. It has been an open and honest discourse, discussion, and we, again, are showing that you can have a difficult conversation in a mature, calm manner. So thank you for that. Now I'm going to blow it up. There's been a lot of misinformation about what this bill does and doesn't do. And I understand that. I understand it is a passionate area. But if you want to talk about the 33 Republicans that were expelled from this chamber in 1868, you not only could, you should. You should talk that history. If you want to talk about the massive oppression under the Jim Crow area that lasted into the 60s, that was primarily from a political party that was resonating in the South at the time, you not only could, you should. You should have those discussions. You should have the discussions about what's going on now. What this bill does, it doesn't, like the senator, my friend up here from the 15th, I can't look at you and say you are inherently superior solely because of the color of your skin. My friend, the senator from the 8th, you are not inherently racist because of the color of your skin. There are 1,000 different things that make up each of us as individuals, and when you systemically, since we like that word today, try to clump everybody of a particular skin color, ethnicity, or race under one umbrella and say because of that you must be this, that is a false analogy. We are sending our kids to school with teachers that we are entrusting to nurture our children. What this bill is doing, and I'm proud of the sponsor for bringing it, is saying you can't, as that teacher, look at one of these kids and call them out and say specifically because of these factors, you fit this category. I understand it's election year. I understand that both sides of this, people are going to use this for or against in a campaign. But I'm begging you, put the politics aside. Think about those kids, and if it's your kid, and this is not your kid saying, the teacher going, you are inherently superior because of your race, because of your ethnicity, because of your skin color, but it's one of those teachers that looks at your kid and says, you are inferior or you are a racist because of your race, ethnicity, or skin color. Mr. President, I yield the well.
Does any other senator wish to speak for or against the measure? The chair recognizes the senator from the 12th for the minority report.
Thank you, Mr. President. Colleagues, this is the Senate Education and Youth Committee Minority Report, March 11th, 2022, not March 11, 1860s, or March 11, 1954, or March the 11th, 1968, and we can go on and on. But it's March 11th, 2022. And here we are again. SB 377 is a bill that is totally unnecessary. Schools, school boards, and even our Department of Education already have processes in place to establish curricula, ensuring it isn't discriminatory what our children are receiving in schools, and responding to parent concerns. 50% of the day is devoted to, by school leaders, is devoted to parental involvement, parental concerns. I know because I've sat in the seat of a principal. The origin of the divisive concepts, the language that's used in the bill, is the result of the previous executive branch of these United States of America to suppress diversity training in our, not only in our public schools, but in our federal workforce. The language has migrated to a series of state-level bills that are pushed by conservative organizations. Bills that use language from this list aim to discourage our teachers from making race or gender salient in conversations about power and oppression. We should not be sending a message that we don't trust teachers when we are already facing massive shortages and high levels of burnout and teacher turnovers. Teachers have been performing miraculous feats in unprecedented circumstances during this pandemic. Vague bans create fear among educators and will lead to more of them leaving the field or deciding not to go into education at all. We need more teachers, and threats from the state will not encourage people to join the educational realm or to remain in teaching. This kind of legislation creates a minefield for teachers and has led to widespread confusion in states where it has already passed. Teachers cannot control questions that students ask or conversations in their classrooms. These bills threaten dire consequences if a teacher's response is misconstrued or seems unacceptable to parents. This bill deprives teachers of free speech and equal protection under the law, and similar bills are facing court challenges as a result. This bill represents an effort to impose content and viewpoint-based censorship. This bill has a foreseeable chilling effect on the speech of educators and trainers, even when crafted in ways that nominally permit free expression. It sends an unmistakable signal that specific ideas, arguments, theories, and opinions may not be tolerated by the government. This bill includes language that purports to uphold free speech and academic inquiry. This language, intended to help safeguard the bill from legal and constitutional scrutiny, does little or nothing to change the essential nature as an instrument of censorship. Mr. President, I leave the well, and this minority report will be filed this day, March 11th, 2022. Thank you.
Thank you, Senator. Chair recognizes the senator from the 50th to close the debate.
Thank you, Mr. President. Thank you, colleagues. I want to echo the majority leader's sentiments earlier. I appreciate the civil discourse today in the chamber. While we do disagree on a lot of things, it's always refreshing that we are able to discuss a bill and not take things personally and discuss the merits of a bill, and I appreciate that greatly. The first thing I want to address is the amendment that's been introduced today by the senator from the 39th. After lengthy discussions with her and other members in this chamber, I would be in support of that amendment and would ask for all of you to support that as well. Next thing I want to address is I want to make it very clear that the people in this room, our governor, our party, our caucus, is 100% in support of teachers. Teachers have a very difficult job, especially recently with the pandemic and having to adjust the way they teach, how they teach, and I commend those teachers, and I applaud the governor for his stance in increasing their pay and increasing support for teachers. And to say or to accuse any of us in this room of being non-supportive of teachers is just wrong, and I wanted to make sure that was made clear. I heard a lot of testimony today about this bill in particular, that we don't need this bill. This bill does nothing. This isn't being taught in our schools. And then at the same time, this bill is vague. This bill is going to hurt teachers. So I don't know how you can talk out of both sides of your mouth and say, we don't need it, this isn't being taught, and then saying, well, no, this is vague. This is a censorship bill. And I've heard testimony today that this would prevent history from being taught. And I want to agree with something the senator from the 40th said the other day about how uncomfortable racial lessons could be, especially at younger ages. And I believe she said when her children got home, she had to sit them down and talk to them and let them know that it wasn't their fault. Because they are children. And we can teach them these hard lessons. But at the end of the day, and what this bill says, is that a teacher should not tell a child that because of their race, skin color, or ethnicity, that they should feel guilty, that it is their fault. This bill allows history to be taught, but what it doesn't allow is for a teacher to then say, because of this history and because of the color of your skin, you should feel this way. Mr. President, I ask for favorable consideration of this bill and ask for your support and the support for the amendment, and I yield the will. Thank you.
Senator has closed debate. We will first take up the adoption of Amendment Number 1. Is there objection to adoption of Amendment Number 1? The chair hears none, and Amendment Number 1 is adopted. The question is on the adoption of the committee substitute as amended. Is there objection to adoption of the committee substitute as amended? Chair hears none, and the committee substitute as amended is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. The question is on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 32, the nays are 20. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, can you please read the caption of Senate Bill 339?
Senate Bill 339, a bill by Senators Kirkpatrick of the 32nd and others, a bill to be entitled an act to amend Chapter 3 of Title 35 of the OCGA relating to the Georgia Bureau of Investigation so as to provide for a green alert program to notify the public when a veteran or a military service member known to have a physical or mental health condition related to his or her service and for other purposes. Mr. President, the Senate Committee on Veterans, Military, and Homeland Security recommends that this bill do pass by substitute. Respectfully submitted, Senator Kirkpatrick of the 32nd District Chairman. Mr. President, Senate Veterans, Military, and Homeland Security Committee offers the following substitute to Senate Bill 339, a bill to be entitled an act to amend Code Section 35-3-171 of the OCGA relating to definitions relative to the statewide alert system for missing disabled adults so as to include veterans who are missing and may have a medical condition and for other purposes. That completes the order, Mr. President.
Chair recognizes the senator from the 32nd to present Senate Bill 339.
Thank you, Mr. President. This bill expands the definition of a Maddie's call to include missing military service members and veterans. The Maddie's call in our current code is an emergency alert for disabled and elderly persons. Local law enforcement takes the information and fills out a form that's transmitted to GBI, who then decides which region should be notified. This bill will allow an additional checkbox on the form for military personnel and veterans. We have seen repeated news articles about missing active duty military personnel, and we also know that some veterans are high risk for mental health issues, including suicide. There's no fiscal impact or additional administrative burden on GBI or local law enforcement with this bill, and I appreciate the help of the GBI with this bill. The bill fits nicely with our mental health efforts, and I would ask for your favorable consideration. Be happy to answer any questions.
You don't appear to have any questions.
Thank you. I yield the will.
Any other senator wish to speak for or against Senate Bill 339? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee sub? Chair hears none. The committee substitute is adopted. Is there objection to agree on the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 50, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, can you please read the caption of Senate Bill 357?
Senate Bill 357, a bill by Senators Kirkpatrick of the 32nd and others, a bill to be entitled an act to amend Code Section 20-2-295 of the OCGA relating to military student transfers so as to provide military students with the discretion to select adjacent school districts for attendance and for other purposes. Mr. President, the Senate Committee on Education and Youth recommends that this bill do pass by substitute. Respectfully submitted, Senator Payne of the 54th District Chairman. Mr. President, the Senate Committee on Education and Youth offer the following substitute to Senate Bill 357, a bill to be entitled an act to amend Part 13 of Article 6 of Chapter 2 of Title 20 of the OCGA relating to organization of schools and systems under the Quality Basic Education Act so as to provide that a military student may attend any public school in the state subject to certain conditions regarding availability and transportation and for other purposes. That completes the order, Mr. President.
Chair recognizes the senator from the 32nd to present Senate Bill 357. The rules chairman must be favorable to the senator from the 32nd. Two in a row.
Thank you, Mr. President. This is a narrow bill that allows students of active duty military parents to attend a school across district lines. There are sometimes circumstances that arise with our deployed military that make it difficult for the child of a deployed service member to go to the school that they would normally attend. For example, if the spouse works in another county far away from their housing or military installation, they can have problems going to get a sick child. The funds would go to the receiving school, the state funds. The bill is agnostic on the local funds, which would be worked out between the districts. This would likely affect a small number of students for a short period of time, since a deployment is a maximum of 2 years. And the bill makes it clear that enrollment is subject to capacity and that the parents are responsible for transportation. I appreciate the help of the Department of Education with this bill. The State Joint Defense Commission hears at every meeting that K-12 education is a priority for their personnel. States are rated by the Department of Defense for their military friendliness, and this is a big item in the rating, and I have this report at my desk if anybody wants to see it for your district. I hope that you'll help me support our men and women in uniform as they deal with their kids' education in these challenging times. This bill passed unanimously out of committee, and I would urge your favorable support. Be happy to take questions.
Don't appear to have any questions.
Thank you. I yield the will.
Chair recognizes the senator from the 2nd to speak to the measure.
Thank you, Mr. President. Although I applaud the senator from the 32nd from introducing a bill to help our military, we all believe in our military, in our state, in our country, because our military is such a strong entity of our great state. But when it comes to local school systems, I want to caution you. When that student enters cross county lines and enters a new county, a new school district, local money does not come with that student. So you got to understand that if it happens one time, it does not hurt the school system. But think of a poor performing school district, and multiple students cross county lines into another school system without the local funds coming with it. It could put a burden on that school system. I applaud our military, but what we don't want to happen is a good school system to be burdened by families crossing district lines, entering a better school system at the expense of no local funds following that student. I urge you, I'm going to vote against this measure, and I urge you to caution not to put burdens on our existing school systems that local funds don't follow. Thank you, Mr. President. I yield the will.
Senator has yielded the well. Does any other senator wish to speak for or against Senate Bill 357? The chair sees none. The questions on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? Chair hears none. The committee sub is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. The questions on the passage of the bill by substitute. All those in favor vote yea. Opposed nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 37, the nays are 11. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Mr. Secretary, can you please read the caption of Senate Bill 359?
Senate Bill 359, a bill by Senators Albers of the 56th and others, a bill to be entitled an act to amend Chapter 1 of Title 15 of the OCGA relating to general provisions concerning courts so as to require a biennial report of recommendation from the Council of Accountability Court Judges of Georgia to various officials of the General Assembly and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland of the 17th District Chairman. Mr. President, the Senate Judiciary offers the following substitute to Senate Bill 359, a bill to be entitled an act to amend Chapter 1 of Title 15 of the OCGA relating to general provisions concerning courts so as to require a biennial report and recommendation from the Council of Accountability Court Judges of Georgia to various officials of the General Assembly and for other purposes. Mr. President, Senator Albers of the 56th District offers the following amendment number 1 to amend Senate Committee on Judiciary substitute to Senate Bill 359 by deleting 6 on line 329 and inserting in lieu thereof 7 by inserting 6 on line 330 after 5. Mr. President, Senator Albers of the 56th offers the following amendment 1A to amend Amendment 1 to Senate Committee substitute to Senate Bill 359 by adding after 5 on line 3 the following delete 7. That completes the order, Mr. President.
Chair recognizes the senator from the 56th to present the measure and the 2 amendments, 1A and 1.
Thank you, Mr. President. My fellow senators, since the summer of 2020, we've had an extraordinary increase in crime, especially violent crime. Gang activity at our state and across the nation is at a crisis level, and they are going after our most vulnerable victims. These are repeat and violent offenders. Consistent with the great work we have done here in this Capitol over the last 12 years in criminal justice reform under Governor Deal and Governor Kemp, we began a process of separating those who we were afraid of versus those we were mad at. Now we have to make sure the ones that we're truly afraid of and committing crimes are held accountable for those crimes. We held a series of public safety meetings which many of you participated in through the summer and fall. This has been well researched, and we met with any and all key stakeholders: prosecutors, district attorneys, levels of judges, police chiefs and sheriffs, the Georgia Bureau of Investigation, the Georgia State Patrol, the Fraternal Order of Police, bondsmen, police foundations, pardons, paroles, community supervision, and most importantly, victims' rights and activist groups. I want to thank Governor Brian Kemp for his forward-thinking and excellent work on convening a gang task force and spending time and the state's resources of going after this criminal enterprise. We have to make sure that our criminal justice reforms are weighted in favor of the victims. This is true criminal justice reform today. Let me take you through this bill because it is a rather lengthy bill. Section 1 is simply the title, the Safe and Secure Georgia Act, because our citizens deserve to be safe and feel safe, whether they're at home, they're at the grocery store, they're on a sports field, they're in their car, or they're at work. The next section requires our accountability courts to simply make reports on an annual basis. As you know, here in the General Assembly, we have accountability put into place where oftentimes we ask groups to submit reports, in this case, the Lieutenant Governor, the Speaker, to our judiciary committees, simply making sure our accountability courts are, in fact, accountable. Section 3. This is punishment for possession of a firearm by a convicted felon or a felony involving domestic violence, changing it from a 1 to 10 year sentence to a 5 to 10 year sentence. Senators, we have an epidemic of violent crime right now. Gang members are committing this violence, domestic violence, gun violence, and we're seeing it in every single district. This is the way gang members victimize people. Mandatory minimums are not a bad thing for violent offenders. If you think about what we did with nonviolent drug offenders, we wanted to make sure there was a path for them to get back into society. But habitual violent offenders are different. We've seen this increase of illegal possession of firearms or ghost guns and gangs that specialize in domestic violence and illegal guns. Some want to debate the accessibility of firearms by law-abiding citizens, and we had that debate about a week ago. This has nothing to do with that. This is making sure we're keeping them out of violent felons' hands. Section 4 is a legislative declaration on gangs. We're going to state what a gang is and does in the law. Now, this is an important statistic, so I'm going to ask you to pay attention to this. Per the GBI, 70 to 90% of our violent crime is committed by gangs. I want you to think about that again for a moment. 70 to 90% of crimes are committed by gangs. We have over 70,000 known gang members in Georgia alone. Gangs are criminal enterprises that operate in the activity of drugs, human trafficking, armed robberies, murders, etc. They recruit our children. Per the Department of Justice findings, they are recruiting 400,000 new gang members every single year, destroying their lives, their families' lives, and the victims' lives. Section 5. This revises the Gang Act to put certain provisions to make sure that the benefits of gang victims, again, the victims who we need to talk about, and their families, can use that criminal activity when they file suit against them. And it also allows the local governments to bring civil actions against gangs, to bring down these criminal enterprises and to identify the gang members. Section 6 revises the Gang Act to expand the venue for Gang Act crimes. Now, we all know that gang members don't know where county lines start or stop. And we need the opportunity to bring all those charges together. This allows us to consolidate those to make sure we go after the drivers of these crimes, which are gangs. Sometimes gangs have even avoided some jurisdictions because of their use of the Gang Act. This will make sure they can run, but they can no longer hide. Now, I want you to hear another important statistic. Gang arrests are extraordinarily low. They only account for 5% charged annually. So think about this. 70 to 90% of our violent crimes are committed by gangs, yet 5% are being charged annually. We need to fix this, and this will help. Section 7 is recidivism punishment for subsequent convictions of act of elder, disabled adult, or minor abuse. These are our most vulnerable, and they deserve our protection. Gang members prey and victimize our elder, our disabled, and our minor population, and they have the highest recidivism rate. This is a much-needed reform, and it works directly with the mental health legislation and conversations we're having today. Section 8 revises the standard for pretrial motions and clarifies objection rules. Pretrial evidence motions are necessary to get cases resolved and streamlined. One of the many recommendations that we received is for more pretrial work. Judges often hear but don't always rule or deny these without a hearing, and we need to codify this. This gives both sides a chance to make a record, prevents unneeded appellate issues, keeps plain errors in the code, and recognizes as a General Assembly that judges need this encouragement. And it was important as it was when this was integrated in tort reform. Section 9 allows evidence of prior acts to be used for the purposes of our elder, disabled, minor, and domestic abuse. We can't allow someone who's got a history of violent criminal activity to not be able to connect those dots. The victims should have the same justice in Georgia as other states already have in the law. Juries have a right to hear the whole truth about that person. These type of offenders are almost always gang members, and they are repeat violent offenders. We have to answer for the abuse of our most vulnerable, and that includes those who are suffering from mental health issues, by making sure we lock these people up, and the state of California should not be more victim-centered than the state of Georgia. Section 10 is to codify video or telephonic conferencing on all matters except for criminal trials. What we learned through the pandemic, that technology can help us to streamline and utilize different forms of logistics to improve the process. This simply codifies that. Section 11 allows the GBI, the Georgia Bureau of Investigation, to assist law enforcement agencies with what's called concurrent jurisdiction. And they can do that for domestic terrorism, cyber, biological, nuclear terrorism, and elections. This is a needed authority, and it certainly makes sense, as nobody better than the GBI has both the resources and knowledge to pursue this. And lastly are the effective dates, to make sure that we can't make something effective that would be already in process through the system. You do have two amendments, 1 and 1A, that was simply a Scrivener's error when we reordered the bill by Legislative Council, just to correct the numbering. In closing, before I'll take any questions, this is criminal justice reform. Each one of us has a painful and personal story by a family, a friend, or a constituent who in the last year and a half has been on the front lines of gang violence, domestic violence, repeat offenders. Criminal justice reform has to be justice for our victims first and foremost. Mr. President, if there are no questions, I would yield the well.
You have no questions.
Thank you. My fellow senators, a vote for this bill will keep people safer in the state of Georgia. It will empower our criminal justice system, our law enforcement, and on your desk, I want to thank some of my colleagues for putting a letter from the Fulton County District Attorney, and I want to thank her personally, her office, and several of their team members, as well as all the folks I mentioned earlier, for putting together such a comprehensive piece of legislation to ultimately protect our fellow Georgians. Thank you, and I yield the well.
The senator speaks with great passion. I'd like to call upon the senator from the 39th.
Thank you, Mr. President. I just wanted to bring your attention to the letter on your desk that has been provided from Fulton County District Attorney Fonnie Willis, which outlines the provisions of Senate Bill 359. She is in full support of the bill. The bill amends the evidence code to streamline the judicial process and improve fairness for all parties by providing that important evidentiary issues be raised and determined before trials begin. And it adds that provision that will allow the use of prior bad acts in prosecutions of serial abusers of children, the elderly, and special needs adults. And it therefore strengthens district attorneys' ability to fight the gangs that are driving much of the crime that we're seeing statewide. I know that there will be concern, and it also gives me heartburn about the provisions related to mandatory minimum sentences in the bill. But one requires jail time for those with a conviction of a forcible felony or domestic violence crime who are found illegally possessing a firearm. And that actually aligns Georgia with federal law and other states and allows us to send a message to repeat violent offenders that Georgia's not a place that looks the other way when you continue to use guns to commit crimes. The other provision that would impose a mandatory incarceration for people convicted a second time of felony abuse of a child, elderly person, or a disabled adult. Those are people who do and certainly should receive a sentence that includes substantial prison time for repeatedly victimizing the most vulnerable. I yield the well.
You have two amendments on your desk. We will call Amendment 1A. Is there objection to Amendment 1A? Hearing none, seeing none, and Amendment 1A is adopted. Amendment number 1. Is there objection? Seeing no objection, Amendment number 1 is adopted. Now the question is on the adoption of the committee substitute as amended. Is there objection to the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to the agreement of the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question now being ordered? The chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Those opposed will vote nay. Mr. Secretary, if you would kindly unlock the machines. On the passage of the bills, the yeas are 37 and nays are 11. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Senator from the 43rd, why do you rise?
Thank you, Mr. President. I ask for unanimous consent to excuse the senator from the 22nd for business inside the Capitol.
Is there objection? Senator from the 22nd, meeting excused. Seeing none, the senator is excused. Senate Bill 378. Mr. Secretary, if you'd read the bill, read the caption.
Senate Bill number 378 by Senators Albers of the 56th and others, a bill to be entitled an act to amend Article 4 of Chapter 5 of Title 16 of the Official Code of Georgia annotated relating to reckless conduct so as to expand the definition of hazing, to provide for inclusion of minors as subject of hazing, to provide for penalties, to provide for the Attorney General to bring civil actions against certain organizations regarding hazing incidents and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland of the 17th District Chairman. That completes the order, Mr. President.
I recognize the senator from the 56th to speak to the bill. He was standing there ready to go.
Thank you, Mr. President. My fellow senators, twice in this body we passed the Max Groover Act, and today once again I wear on my arm Fly High Max in this bracelet in honor of Max Groover, who lost his life several years ago in a fraternity hazing accident. His mom, Rayanne, and father, Stephen Groover, have made it their life mission to help. Last year, we passed this bill. Unfortunately, during its time in the House, some of its key components were removed. And we passed what I asked you to do on the final day of legislation, which was the first installment. This simply puts back into the law everything that we have passed 2 times before in this chamber. I want to thank everyone who added to this, specifically the senator from the 41st, where we worked to amend that to add age 17 or above. This does add the provisions of hazing, creating it to a felony for those who cause severe bodily harm or death. It does create the opportunity for folks to have immunity when they assist with getting the proper resources and help needed when someone is in trouble. It does exclude NCAA sports, ROTC, and anything under the Department of Defense. Again, this bill passed unanimously twice before. I'm going to ask you to do it one more time to help keep our children safe and send a strong message to all those that we care about our clubs, our sororities, fraternities, and bands, but we want them to be both safe and accountable. If there are no questions, I would yield the will.
You have no questions, Senator.
Thank you.
Does any other senator wish to speak for or against the bill? Chair hears none. Is there objection to agreeing to the report of the committee that is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is objection to the main question being ordered? The chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor of the bill vote yea. Those opposed vote nay. Mr. Secretary, unlock machines. Keep the hammer down, boys. We're going to get out of here. On the passage of the bill, the yeas are 44 and the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, if you'll read Senate Bill 519.
Senate Bill 519 by Senators Tippins of the 37th and others, a bill to be entitled an act to amend Article 3 of Chapter 18 of Title 15 of the Official Code of Georgia Annotated relating to Solicitors General of State Courts so as to provide for the honorary office of Solicitor General Emeritus, to provide for qualifications, to provide for a certificate, and for other purposes. Mr. President, the Senate Committee on Government Oversight recommends that this bill do pass. Respectfully submitted, Senator Harbin of the 16th District Chairman. That completes the order, Mr. President.
Call upon the senator from the 37th to speak to the measure. If everybody will move briskly, we'll get finished before Mr. President returns from lunch.
Thank you, Mr. President. Fellow senators, I bring Senate Bill 519. This is a bill and subject matter that we have seen before. It creates the honorary office of the Solicitor General Emeritus. We passed this bill overwhelmingly last year. This confers an honorary title on those who have served as a Solicitor General and as a prosecuting attorney for 20 years and have been honorably retired. This bill exactly mirrors the same language dealing with the retired district attorneys. There's no cost to the state. There's no special privileges conferred on this other than the recognition of the title and their good service to the state of Georgia. Mr. President, if there's no questions, I yield the will.
You have no, well, take that back. You do have one question. From the, senator from the, Chickamauga, Northwest Georgia.
Great state of Chickamauga.
Senator Yield.
Absolutely.
Senator Yield.
Yeah.
Senator, could this be your last bill as a senator?
I certainly hope not.
Oh, you got some more? Well, we'll talk to the rules chair, make sure you get a chance on that.
Thank you, I appreciate it.
But I want to thank you for such an outstanding bill and the Solicitor General Emeritus, so thank you so much. I have no questions.
Thank you. You as well.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the agreeing the report of the committee is in favor of the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor vote yea. Opposed vote nay. Mr. Secretary, unlock machines. On the passage of the bill, the ayes are 42, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, if you'll read Bill 534.
Senate Bill 534 by Senators Kennedy of the 18th and others, a bill to be entitled an act to amend Title 50 of the OCGA relating to state government so as to provide certain procedural requirements and considerations for the adoption of rules by state agencies that are applicable to charitable organizations and for other purposes. Mr. President, the Senate Committee on Government Oversight recommends this bill do pass. Respectfully submitted, Senator Harbin of the 16th District Chairman. That completes the order, Mr. President.
Call upon the senator from Macon, Georgia, senator from the 18th, to speak to the bill.
Thank you, Mr. President. It's good afternoon. I know it's Friday and we all want to go home, but we've got a couple more bills. And this is a simple, straightforward bill and an opportunity to help charities in the state of Georgia. Fortunately, we have a high rate of philanthropic giving in Georgia, and we've got a lot of substantial and very important charitable organizations who have had a difficult time over the last couple of years with COVID-19. This legislation simply helps Georgia continue to attract and retain charitable entities that meet the needs of our local communities. It protects charitable entities so that they can focus on their mission rather than having to comply with arbitrary or unilateral mandates that may be different from that which we as legislators say that ought to be on them. It provides also transparency by ensuring that the new requirements for charitable entities relating to the filing and reporting requirements would have to first be provided a notice given to the legislature. The legislature can then determine what measures are appropriate. That, of course, is our role. These issues are concerns to charitable organizations around the country, and that has produced, in fact, similar legislation that's been passed in 7 other states of recent. So what does the bill do? Very simple. It simply says that in the formulation or adoption of any rules that place administrative burdens on charitable organizations, that the agency should, when it is legal and feasible in meeting the stated objectives of the statutes that we pass, establish a less burdensome compliance requirement to clarify, consolidate, and simplify the compliance obligations on charitable organizations, and provide an alternative for charitable organizations in the event that, so that they don't have to have fees, unnecessary fees, and additional paperwork required for them to submit in the event that it doesn't meet the statutes that we pass. So with that, Mr. President, I'll also tell you that some of the local supporters that you'll recognize, of course, the Marcus Foundation, that we all recognize as local with national implications, the Philanthropic Roundtable also support this effort, and many other charitable organizations in the state of Georgia. This bill comes to you with bipartisan support from the out of the committee where it was voted out unanimously that heard it and sends it to you for consideration. With that, Mr. President, I'm happy to answer questions or yield the well.
You do have questions. Senator from the 9th. Senator from the 14th, 41st. Senator from the 41st.
Senator, do you yield?
Yes.
Senator,
That's you.
I ran to get over here to ask you questions.
Do you need a moment? That's fine.
Senator, did you have a chance to speak with anybody from the Secretary of State office about this bill?
The Secretary of State's office reached out to me by text 2 days ago and wanted to speak or meet. I said, I'm happy to. Let me know when you're available. And then I did not receive any information from them that day or yesterday. And then I had an inquiry this morning about talking about the bill, but no specific request, no specific objections. And of course, the bill is on for the calendar to be, on the rules calendar to be heard today.
So, Senator, you further yield?
Yes.
So is it not true that you did not reach out to the department as you were drafting this bill?
No. Why would I do that, Senator? That's certainly not a normal process for your approach, as I understand it.
Do you further yield?
Yes.
Senator, is it not true that when we work on legislation, it's helpful when we talk with all of the constituents and parties that are involved who might have some impact or be impacted by the legislation we draft?
Sometimes there's utility in doing that, but I think, senators, as you are aware, usually when the legislation drops, anyone of interest, it goes public, they have a right to interface with us. They have a right to come to the committee hearing. And I think, as you know, since, as I recall, Senator, you voted for this bill to come out of committee, as did everyone else on the committee. This bill has been in the public forum for many, many days now, and I've not heard from anyone with the exception of one text message that I alluded to. So I want to make sure we're clear and that the members of this body are clear that there's been ample opportunity for whichever agency might want to interface with me on this or discuss it. I'm always available to do that, but the bill's on the floor now.
Sir, do you further yield?
Yes.
So just substantively related to your bill, can you tell me what are the current onerous requirements that a charity that's trying to register in the state, what's difficult about the process as it already exists?
Well, Senator, I think you may be misreading the bill. If you'll look at the language of the bill, what it does is say that the requirements that are there now should not be made more onerous, should not be made more problematic, should not be, and in fact, one of the examples, if you'll look on line, I think it's line 62, that where the same information is provided by the charitable organization to one governmental entity, that they shouldn't have to provide it multiple times. These are putting additional financial and resource burdens on charities who are strapped these days with the difficulties coming out of COVID-19.
Do you further yield?
Yes.
So are you suggesting that the Secretary of State's office currently is creating these onerous process and demanding additional paperwork that's a burden to charitable organizations?
Now, Senator, again, I think you misunderstood my question or you haven't read the bill.
Oh, I've read the bill.
Well, but you're asking a question that is different from what's in this bill in this regard. Your question presupposes that this is trying to lessen the burden, and the heart of this bill is so that we don't put increased burdens on charitable organizations that are unnecessary, that are duplicative, that are wasteful.
Do you finally, one last question, do you yield for one last question?
Sure.
So, Senator, are you aware that in the last year, the Secretary of State's office received 0 complaints about the way in which their process operates, that they've had 8 organizations request waivers for the onerous, for the application process, 8 of which they have granted. Senator, are you aware that they've received numerous acclimates for the way that they handle their process?
No, Senator, and you've not given any details. I don't know the 8 that you're referring to. I don't know the source of the information. I don't know who at Secretary of State's office, for some reason, chose to interface with you rather than me, the author of the bill that's bringing forth this legislation. So it's hard. I don't think you're misrepresenting anything, but you're giving some very vague information without any sources, without any authority, or without telling us where that information came from. So I don't want to get into a yeah, I agree with all of that because I don't know the source of that. Again, the purpose of the bill is so that we don't have bureaucrats that are creating a regulatory, burdensome environment on our charitable organizations that is beyond that which we as legislators decide is the appropriate level that ought to be placed on the charities of Georgia.
Do you further yield?
Is this the third last one?
So that, I mean, you
That's
asked me a
fine.
question. So just
Sure.
so I can notify my sources, verify my sources, this information comes from the Director of Securities and Charities Division of the Georgia Secretary of State's Department, which responded because I've made a phone call and asked to talk to them about this bill. By way of question, is it not true that there was no public comment made about your bill until after we had already passed it?
Senator, I'm not aware of any public comment that was made at the committee level. In fact, I think no one came to speak. So I don't know what you're talking about when you say afterwards. I presented the bill at the committee. It passed out of the committee. I left the committee to go to something else. So you're implying that there was some public comment afterwards, and I don't think that's part of the record.
Senator from Middle Georgia, you have no further questions.
All right. Thank you, Mr. President. I ask for your favorable consideration. I yield the will.
Does any other senator wish to speak for or against the measure? I recognize the senator from the 9th.
Thank you, Mr. President. As was noted, SB 534 did pass out of the government oversight, which I sit on, as well as the senator from the 41st. And we passed the bill without some key testimony. We did have someone come out and testify against this bill, and it did happen after, and I'm not sure if they were missed during sign-up. I'm not sure why this young lady was not giving time to talk while we were discussing the bill. But a few things I want to point out about the bill, and I am encouraging you to vote no on this bill. For one, we already have, relaxed, deregulated examples of we already have relaxed deregulation as compared to the rest of the country. And there have been examples that charities that have been kicked out of other states, they come to Georgia because we do have relaxed operations here is how we regulate charities. And just last year, Cherokee County indicted 14 people on more than 100 counts of racketeering, criminal gang activity, and charity fraud. And this last month, the Secretary of State warned of scams to look out for and not-for-profits, charities, as related to the Ukraine crisis, those that may be trying to use charities to raise money because we're due to the crisis. Also, if you guys look on your desk, we have Attorney General Chris Carr has also warned of charity fraud. And just a few other things I want to point out, and this is from the testimony that we got. To register for a nonprofit, it's a simple $35 registration fee. If you raise less than $500K, it is unaudited, unreviewed on a financial statement. If you raise no money, you don't have to provide any financial statement. You can have a $20 million nonprofit come to Georgia and pay $25 every 2 years and be registered to solicit constant and uncapped financials. The statute right now empowers our Secretary of State to regulate the rules when it comes to nonprofits, but this would create a new law that the legislature has to review the regulations. And that's it's going to make it less burdensome. It's going to be compliance requirements. And it's going to put a burden on our legislature as far as research and time in adopting these rules. So I know the bill looks like, it's no harm in it, but we do already have relaxed regulations, and I'm asking you to vote no on this bill. I yield the will.
Thank you, Senator. Does any other senator wish to speak for or against the measure? Seeing none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The committee report is agreed to. Is there objection to the main question being ordered? The chair sees none. The main question is ordered. The question on the passage of the bill. Those in favor vote yea. Those opposed vote nay. Mr. Secretary, if you unlock the machines. Senator from the 53rd, why do you rise?
Parliamentary inquiry.
Parliamentary inquiry. What state your inquiry?
Yes, sir, Mr. President. Isn't it true that some people say that your voice has more gravel in it than an old graveled road?
I think you heard that from my wife. Senator from the 9th.
Parliamentary inquiry.
State your inquiry.
Mr. President, is it true that if you vote yes for this bill, you are in favor of reduced regulations for charities and nonprofits?
About what she speaks. On the passage of the bill, the yeas are 34, the nays are 12. This bill, having received the requisite constitutional majority, is thereby passed. Appreciate it. Mr. Secretary, if you would read Senate Bill 54.
Senate Bill 54, a bill by Senators Harbison of the 15th and others, a bill to be entitled an act to amend Article 1 of Chapter 9 of Title 19 of the OCGA relating to general provisions regarding child custody proceedings so as to provide judicial discretion in determining the right of a surviving parent to custody of a child when such surviving parent is criminally charged with the murder or voluntary manslaughter of the other parent and for other purposes. Mr. President, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland of the 17th District Chairman. That completes the order, Mr. President.
It is my honor to call upon the senator from the 15th, the City of Fountains, to present the bill.
Thank you, Mr. President. I bring to you Senate Bill 54. From 2017 to 2021, there have been 659 known incidents of fatal domestic violence in Georgia. Those incidents accounted for some 840 deaths of victims, abusers, bystanders throughout the state. The majority of these incidents are homicides, where the abuser takes the life of the intimate partner victim. Oftentimes, these parties have minor children together, leaving those children without a surviving parent to care for them. Nearly half of the fatal domestic violence incidents involve children in some capacity. Children were present, involved, or hurt, killed, or lost a parent. There were 196 incidents identified where one parent killed another parent, leaving at least one minor child under the legal custody of the killer. Those surviving parents, homicide perpetrators, are believed to have remained legally able to exercise their discretion over the child's living arrangements. So this is an effort to alleviate that situation, to bring some justice to the surviving parent's family, and that particular situation that has occurred more than 196 times. So I submit Senate Bill 54 to you for your consideration and prayerfully your favorable vote. If there are no questions, Mr. President, I will yield the well.
You have no questions.
Thank you, sir.
Does any other senator wish to speak for or against Senate Bill 54? The chair sees none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 50 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Secretary, can you please read the caption of Senate Bill 603?
Senate Bill 603, a bill by Senators Robin of the 5th and others, a bill to be entitled an act to amend Article 11 of Chapter 2 of Title 20 of the OCGA relating to public school property and facilities so as to provide for an outdoor learning spaces pilot program and for other purposes. Mr. President, the Senate Committee on Education and Youth recommends that this bill do pass. Respectfully submitted, Senator Payne of the 54th District Chairman. That completes the order, Mr. President.
For what purpose does the senator from the 50th rise?
Mr. President, I move that we table Senate Bill 603.
Senator from the 50th has moved that the Senate place on the table Senate Bill 603. Is there objection? The chair hears none, and Senate Bill 603 is placed on the table. For what purpose does the senator from the 54th rise?
Yes, Mr. President. I move that the Senate disagree to the House amendment to the Senate substitute on HB 517.
Mr. Secretary, can you please read the caption?
House Bill 517 by Representatives Carson of the 46th and others, a bill to be entitled an act to amend Chapter 2A of Title 20 of the OCGA relating to student scholarship organizations so as to provide for the inclusion of earned interest in the calculation of minimum revenue obligations for scholarships and tuition grants and for other purposes. Mr. President, the House offers the following amendment to the Senate substitute to House Bill 517. Representative Carson of the 46 offered the following amendment to amend the Senate substitute to House Bill 517 by replacing line 18 with the following: in a partnership, revise the aggregate annual limits of the tax credit and for other purposes. That completes the order, Mr. President.
Senator from the 54th has moved that the Senate disagree to the House amendment to the Senate substitute to House Bill 517. Is there objection? The chair hears none, and we have disagreed. Chair recognizes the majority leader.
Thank you, Mr. President. I move that the Senate stand adjourned until 10 a.m. on Tuesday, 15 March 2022.
That's a little early. Mr. Secretary, do you have any announcements to make?
All committee meetings have been canceled for today. However, on Monday, there are an abundance of committee meetings. So we have left on your desk the schedule of committee meetings for Monday for your reference. That completes the order, Mr. President.
Does any senator wish to make an announcement? The chair recognizes the pro tem.
Mr. President, isn't it true that I would like to thank the chamber for their work today and keeping us on track and getting us finished. And we will have lunches on the days that will go extended time, but had we had lunch today, we'd be getting out here at 3:10 instead of 2:10. Have a great weekend. Thank you.
Thank you. Chair recognizes the majority leader.
Thank you, Mr. President. Just as a reminder to everyone, next Friday will be a Bullitt sequel. So Gene's on Friday. John Bullitt, the second day. And then remember that Thursday is St. Patty's Day for those who want to dress appropriately.
Thank you for those great reminders. The chair recognizes the senator from the 20th for an announcement. Oh, I was going to call you out on that.
Just wanted to make everybody aware that's on the Senate Ag Committee that we are having a meeting Monday at 4 p.m. Monday, Senate Ag and Consumer Affairs. It'll be in the mez. Thank you.
Chair recognizes the senator from the 56 for an announcement from his desk.
Thank you, Mr. President. I just learned from the senator for the 53rd that it might be against policy and protocol of the Senate if the senator from the 7th dressed up like a leprechaun on the 17th. Is that not true?
That sounded more like a parliamentary inquiry, but the chair sees great meaning in that. Will the senator from the 7th stand? Chair recognizes the senator from the 42nd for an announcement from her desk.
Thank you, Mr. President and colleagues. Just wanted to announce and thank our doctor of the day, who is Dr. Patrick Hall, an internal medicine physician with Kaiser Permanente, who serves as the East Area Chief for Adult Primary Care within Kaiser. Thank you, Dr. Hall.
Chair recognizes the senator from the 35th from her desk for an announcement.
Yes, thank you. I'd like to thank the 5 schools that came here today with the young kids for the Child Rescue Crusade. And some of them are still walking around getting a tour now. But thank you very much to Good News Church and School of Johns Creek, because they were the ones that stayed all day long. Thank you.
Thank you for that. The majority leader has moved that this Senate stand adjourned until Tuesday, March 15th, 2022 at 10 a.m. All those in favor of the motion signify by saying aye. Opposed, no. And the ayes clearly have it, and the Senate stands adjourned.